Well, today is the final day of the Conference on the National Development Plan and State Capacity held at the University of KZN, hosted by the Department of Public Service and Administration. Now, the event, which started on Monday, is a reflection on state capacity and government performance in the first 10 years of the National Development Plan. The conference heard that there is no direct linkage in measuring the NDP against state performance. On Monday, Acting Public Protector Advocate Gcaleka spoke under the heading Reflections on the Capacity of the State, what the Public Protector Investigation Report highlight on state capacity and government performance. Well, the Acting Public Protector joins us now to have a little bit of a conversation. Great to have you. Thanks so much for joining us.
Good morning, Leanne, and good morning to the viewers. Thank you for having me on the show.
It's an absolute pleasure. So this particular event that we were talking about was really packed with various themes, but it all ponders on the role of the state in driving development through policies that will be carried out by state institutions. What were the reflections that were shared over the past 10 years?
Leanne, basically the reflections that we shared was that the picture doesn't look that good. However, there is room for improvement. We don't see much compliance. Let me first speak from our side as the public protector, looking at the reports that we have concluded. You know, there's not much compliance with the policies available. There is not much implementation of governance reforms. For instance, our remedial action take the form of reforms of the systems to ensure, firstly, the drive in service delivery, compliance with policies, ensuring that there's no undue delay in providing services to the citizens of South Africa. And over and above, I mean, looking at the NDP itself, in which the public protector is mentioned under Chapter 14. And when you look at the execution in terms of fighting crime in the country and corruption in particular, there is a will. But when you look at the strides that have been done, we think that a lot more can be done by curbing maladministration. And in doing that, systems need to be implemented.
So I suppose the question really needs to be asked is, where do you place the role of the public protector, the South African public protector, in all of this? I mean, that is driving development, the implementation of policies, and the efficacy of state institutions in rolling out programs and carrying out the work of government.
The Constitution places at the center of that, because according to the Constitution, we are the vanguard of this democracy. Our role is to strengthen constitutional democracy by ensuring that we investigate any malfeasance in state affairs, which actually become a blockage between the citizenry and government. And we've seen that in most of our reports, that causes a lack of service delivery, that causes governance gaps, which we are responsible, that causes a lack of ethical leadership, as you are aware that we are also responsible for investigating ethical conduct, particularly in those who are holding state power in terms of the Executive Members Ethics Act. And we are also responsible into looking into the systemic blockages that affect the running of the state, good governance, and so forth. Therefore, it really places at the center and at a very critical position, particularly at this time. And I must say, commending so that the DPSA has taken the initiative to actually review and consult institutions such as ours to be able to see where do we see the capacity of the state.
And I mean, that is a big thing, because at the center of the discussions yesterday, which has become an everyday topic in South Africa, is the setback caused by incapacitated, inefficient state, levels of corruption, the lack of accountability, non-service delivery. These are things we see in every direction we turn, not only at local government sphere, but also at the provincial and national levels. Things really seem to have taken a turn for the worst in South Africa. In the discussions of the conference, who should take responsibility? Where does the blame really lie?
The responsibility lies with all of us, and we all have to take responsibility and enforce the powers that we have to ensure that we get the state apparatus going. For instance, from our side as the public protector, we need to take more responsibility to enforce the remedial action that we take that ensure that there is redress of whichever conduct which prejudices the citizenry of the republic, which prejudices good governance, which doesn't ensure accountability, as you've stated. I mean, at the core of it is accountability. But government itself needs to take responsibility in driving the programs that they've put in place, in ensuring that there's compliance therewith, but in ensuring that there's continuous monitoring and evaluation. And I think at the center of the discussion was the issue of monitoring and evaluation. Where does that lie, and what then becomes the outcome of that, and what is then done thereafter? And that's very critical to be able to do a self-assessment. But Chapter 9 institutions are there to do the assessment of government and advise government on their blind spots. But the issue is the implementation of the advice that is being provided that we need to ensure that we enforce.
Yeah, and that, I know you spoke to that because, you know, there's this intention to act on failure to implement the recommendations of the Public Protector's Office and make it a criminal offence. And that's something that, you know, we'll always hear about, but it never seems to happen. What is the plan on the matter, and which legislation do you intend to utilise?
We intend to utilize the Public Protector Act, which we are currently in the process of reviewing. We've already identified areas of reviewing. And I think this really comes from the Nkandla judgment, which has pronounced that the remedial action of the Public Protector is binding. I mean, the court is very clear in that judgment that there needs to be enforceability, you know, and it has a legal consequence. Now, we need to ensure that that legal consequence is then seen. And how does that derive? Because of the development of the jurisprudence of the Office of the Public Protector through case law, we then need to align our act accordingly. Already in our act, we have where there's failure to adhere to a subpoena, we can then open a criminal case, and that results into contempt. Now, we want to put the same legal effect in respect of our remedial action, where the state ignores the remedial action, which actually happens 95% of the time.
Yeah. I want to talk a little bit about some of the investigations, and I think it's important that we have you here just to get an update and to also speak about what is happening, and I suppose the most high-profile one, and I know this is not the only investigation that the Public Protector's Office is embarking on, but the most high-profile, and the one I think people really want to know where you at this, is that on the Phala issue. Where are you? Are we going to be getting any results soon? Is that investigation happening, ongoing, and near completion?
The investigation is happening ongoing and at an advanced stage. I mean, we have capacitated the process to have 2 investigators, quite senior, knowledgeable, and experienced, and they report to the executive manager responsible and the acting COO, who are working around the clock on the investigation. I mean, most of their time they spend on the Phala investigation. We have volumes and volumes of information and evidence which we have obtained, but also we still have quite a number of follow-ups to make. As you know, the process of investigation is in such a manner that you might think you would finalize it tomorrow, and tomorrow you actually get evidence that leads you to 10 more other sources which you have to follow on, and it totally takes you to a different direction. But I am confident that we are making strides. We are working within a reasonable time, and actually considering the time frame of the investigation and similar investigations, I think we have done quite a lot of progress in the investigation.
But a lot of people, and I mean including some parties, marching to the Public Protector's Office saying that this is taking far too long, and there are delays that, you know, that should not be there. I mean, this has been going on for a few months now. this should be near completion. So you say you're at an advanced stage. Are you going to put your head on the block and give us a time frame? Will it come out before December? Because I suppose that's what everybody's waiting on. Is this going to be something that will affect the president come the national conference or not?
Fortunately, Leanne, we investigate in line with the Constitution, which gives us the mandate to be independent, to be impartial, to investigate fairly, to investigate without prejudice, and without any alignment to anyone. And we need to conduct our processes in that manner. We need to ensure that there is a fair outcome that is highly procedural. There's several case law against the Office of the Public Protector on rushed investigations, not following due processes, not giving the respondents sufficient time to respond to our allegations. And those have really dented the integrity of the Office of the Public Protector. Now, we need to ensure that we learn. And I'm not certain of the delays. I mean, similar investigations, I'm going to speak of the Gcaleka investigation. It took the Office of the Public Protector 2 years, 5 months to investigate. The state capture, it took the Office of the Public Protector over 7 months to investigate. And even then, the investigations were not concluded. It was passed over to a commission of inquiry, which was headed by the Chief Justice Zondo, who took over 4 years to finalize it. And the danger of putting time frames to investigations is that you find yourself having to extend those time frames time and time again. I mean, from the Zondo Commission, we saw that happening. Justice Zondo would go to court and request a further 3 months to finalize the investigation, and have on several times extended those 3 months because of how an investigation evolves. But let me just assure South Africans that because of our independence and our impartiality as the Office of the Public Protector, and having the critical role of strengthening our constitutional democracy, we do not investigate for a cycle or for a season or for a political event. We investigate in the best interest of the members of the public, the South Africans, our constitution and the law.
Yeah, indeed. I understand the extensions, but certainly I'm not sure we can compare the Office of the Public Protector to anything like an inquiry. This is a very different setup. So I suppose comparing to a Zondo Commission and a Public Protector's Office, very different divisions here.
It's very different because the Office of the Public Protector doesn't have a special budget for the Phala Phala investigation. It doesn't have a special resource for the Phala Phala investigation. These are investigators who, in addition to the Phala Phala investigation, have got a lot of other matters to investigate. I mean, our workload is at an average of 45 files per investigator. And all of these matters are urgent. We've got matters of water shortages, electricity, bread and butter issues, roads, infrastructure that affect the people of South Africa, and which are equally important to South Africa. So indeed, it is different because our resource we use from the budget that we receive from government, and there's no additional resources. We have to make means with the less investigators which we have as the Office of the Public Protector.
Indeed, but as the pressure was on to get the whole probe into state capture done, because it involved a sitting president, this also involves a sitting president. And I imagine this should take preference and priority to finalize as soon as possible.
As I've alluded, it is actually, hence we've put aside the resource within the limited that we have, and we are putting the extra time into that. And also that, as you allude to this matter of the sitting president, it took over 2 years. And we are not even halfway there in respect of this investigation. And I'm not saying that we would even get there. At the rate at which we are working, it will not take 2 years or even more than that to finalize this investigation. But more so that it entails a sitting president. I want to make an example of the CR17 Busasa matter. That matter took us between 8 and 9 months, which we have not reached in this particular matter to finalize. And if you look at the criticism that we received from the court in how we conducted that particular investigation, I do not want to put the institution nor the country in that particular position. I want to put the institution in the country in the position where we are able to produce a report that has integrity and that can stand the test of the courts.
All right, we'll leave it there. Advocate, thank you. Thanks so much for talking to us here on the programme. That's our South African Acting Public Protector Advocate, Gcaleka, discussing the role of the Public Protector in creating state capacity and government performance, and also, of course, updating us on issues around Phala investigation.